and welcome to All Things ESL. I'm Hannah Benson. This is a podcast for ESL educators and administrators. This month, we are discussing DACA, more recently dubbed the Dreamers, and our legal obligation toward them. There are so many things we are required to report at work that delve into our students' personal lives. In some school districts, home visits are required. But at the same time, when I manage my ESL caseload, I only have to type in DACA, where their social security number would appear, and leave it at that. And of course, as a trusted member in the ESL community, my students freely share how they arrived in this country, many of them clearly illegally. So my question was more than curiosity driven, as I believe that if you're a professional in your field, you should be pretty clear on how you can get into legal trouble. The more I dove into this issue, the more I realized there's a ton of history here. A lot of history that, embarrassingly, I knew nothing about after receiving my master's diploma in ESL. If any of you were required to take a history of ESL course in your graduate program, please tell me, and I will boost your university on my blog. So here it is, the history lesson we never got. We're starting out in 1968. The Bilingual Education Act, also known as Title VII, was the first federal legislation that recognized the needs of limited English students. That's right, 1968. This is way after the Chinese immigration wave around 1820, way after the Italian immigration in 1880 to the early 1900s, not to mention the World Wars. Yeah, we didn't start catching on until the late 60s. So much for give us you're tired, you're poor. Just don't expect them to be educated here. Actually, the Bilingual Education Act was to aid special education language learners, recognizing they might need help in their own language. But this in itself was not ESL. It was not an opportunity for students to learn the English language and other subjects in simplified English. It was bilingual education, which, gracious, aren't we so behind in special education language learning? But that's another topic for another episode. So I guess, really, we're starting out in 1974, not 68. This is when a school district in San Francisco had 2,856 students of Chinese ancestry. And for the record, there were way more students in the school who were English language deficient, but we're just talking about the Chinese population for the sake of this court case. So of these 2,856, 1,000 are getting help by English language instruction. So almost 2,000 are sitting in a class with no instruction twiddling their thumbs? Not exactly. Apparently, a little over 2,000 Chinese were receiving some instruction in Chinese, but 436 of those students in the Chinese class were not Chinese. They were just thrown in the mix for, quote, ethnic balance. America. Politically correct man strikes again. And you know what always amazes me about these cases, like Brown versus Board, which fought for equal education rights for African Americans, which, by the way, was only 20 years earlier. Someone receiving poor education has to stand up for themselves and say, hey, this isn't fair. It's got to change. The thing that makes this case most fascinating is the fact that they literally didn't have the words to be able to speak up for themselves. It's the lawyer that tried the case, Ed Steinman, who represented these students and apparently is still fighting for the rights of ESL students from the original case, just to make sure they are keeping their end of the deal. I was able to track Ed down, and he agreed to speak with me about the case. Ed is a civil law attorney who's working as a law professor at Santa Clara University.
Hello.
I'll let Ed give you his resume.
I was the attorney who brought and won the Lau versus Nichols case. I have been involved the last 45 years in trying to implement it, both in San Francisco and nationwide. I've been on a national Lau commission in the 70s. I have been in other commissions throughout the country, and I have probably given over 800 talks on the issue the last 45 years. I also teach law and education in a law school course.
Okay, so let's get back to it. A class action suit was made by the students claiming they were not receiving 14th Amendment rights against discrimination.
I was an attorney for all of 4 months. I was 25 years old. So I was a lawyer in the Chinatown office of a legal services organization. I had clients who I needed an interpreter. And it didn't take a rocket scientist to realize if I need an interpreter, that means that they basically live in a world without English. And what about their kids, which is what I'm concerned about. So during the first 4 months of my practice, I had my interpreter ask, well, they're here for one reason. Do me a favor, ask them some other questions. And I put together basically facts that the children in San Francisco, both in the Spanish-speaking and as well as then, of course, it was Cantonese-speaking, they were basically not getting education.
The school claimed it was being fair because they were providing each student with a teacher they couldn't understand, a handbook they couldn't read, a syllabus they couldn't read, and a textbook that they couldn't read. But in their point of view, they thought, hey, the non-native speakers are getting the same materials that our native speakers are getting.
And this is a sentence from that decision. Quote, the discrimination suffered by these non-English speaking children is not the result of laws passed presently historically by the state of California, but the result of deficiency themselves in the children failing to learn the English language.
Ouch. So basically, if you were born into some stuff that disadvantages you at life, it's not the school's problem to educate you to help you overcome it. The district court denied them, and the Court of Appeals agreed. I know. So finally, it was escalated to the Supreme Court case. They realized, hey, mandatory school time, plus the rule that no one can graduate without mastery of the English language, was turning out a whole bunch of uneducated but potentially helpful citizens. I asked Ed how optimistic he felt when the case got brought to the Supreme Court.
Well, I didn't feel like it could still win.
Still, the case was overruled unanimously. All 9 Supreme Court judges ruled in favor of the Lao children. At the very beginning of our conversation, Ed started talking about the significance of the case's impact if it had never been reversed in the Supreme Court.
I emphasize something which is just very serious, and I know that your audience understands it. The U.S. Supreme Court takes very, very few cases. But if the Lao case had not been accepted, it had not been one of the lucky 1 or 2% they took, and of course we say lucky because we got it reversed, it would have been binding in 8 or 9 Western states, and it would have been very influential, although not binding in the rest of the country.
Ed said that the real difficulty, and one that still keeps him employed in keeping after the schools, is just that because he won the ruling, the real battle is being played out every day at the local level.
The U.S. Supreme Court reversed that 9-0. You don't reverse that attitude. You don't reverse that in legislatures. You don't reverse that in school districts that are more hostile to these kids. And at the risk of offending your audience, you don't reverse it in teachers who maybe don't want to retrain to become ESL or bilingual.
Regardless of his lack of background in education, it was clear that Ed had an intimate grasp of the frustration we find when working with general education teachers. The district asks them to get an ESL designation in addition to their degree to meet the needs of the district's ESL students. There's an indignation there, and we've found it in our administrators too.
One of the problems we have is that when I went to school, kids look like me. I'm white, I'm middle class, I speak English. That's not what kids look like today. And the problem we have in this country is that when the student body changes, we haven't forced the school districts or the teachers to change. And if someone has to suffer, I want no one to lose a job. If someone has to suffer because the students are different, it shouldn't be them.
I asked Ed if there were still cases being fought similar to the Lau versus Nichols case, if schools were still not providing services clearly demanded by the state, and in many cases being given funds to fulfill those requirements.
Yes, they are being fought, and they're being fought in 2 different ways. First of all, most of the cases are brought in state court under state constitutions or state laws, but you've seen nothing in the federal courts because the presidents and the education department have not been interested.
Regardless of this last statement, this is a bit embarrassing, but I was surprised to hear that these cases were still going on. I don't know why I'm surprised, except to say that perhaps in my own little classroom, in my own little slice of the ESL world, I tend to be grossly out of touch with what's happening in my own field. I suppose that's another reason I wanted to start this podcast. My approved PD hours just weren't cutting it in terms of being up to date in my field. Okay, so before we continue, allow me to make a two-way disclaimer. I have no law background at all, and so sought advice from Ed Steinman. And while he speaks to the law, he is not an ESL teacher. So while he freely gave his opinions as to what teachers should and shouldn't have to do, it was clear that he was not in our position currently. You'll see what I mean.
Many of the cases are still wanting the notion of an appropriate education, notion of a meaningful education, the notion of an education understandable to the child. That means there has to be some element of bilingualism.
Now, some of you may disagree with this, but I would say for the majority of ESL teachers in America today, we are not bilingual. And actually, when in a class where there is a language majority in which I have some fluency, I make sure my students don't know this fact for as long as possible. And personally, I believe it's best not to speak the home language of the student to whom you're teaching English. So it puts them in a situation where their language learning becomes more of a necessity if it wasn't needed to make friends already. On this point, it seems California agrees with me. Apparently, there is an emergency ESL course for brand new ELLs that is full English immersion. Bilingual options are available later for interdisciplinary courses. But we're getting off track. So let's get back to what's happening now. LawyersCommittee.org wants everyone to know that the 2020 census is going to feature, for the first time ever, a citizenship question. There is a lawsuit being filed against it, but yeah, that's happening. Education Week posted that legislation has been introduced banning immigration agents, they work for ICE, by the way, from, quote, conducting arrests, interviews, searches, or surveillance at schools and bus stops. Honestly, I've never witnessed an ICE intervention at any school where I've ever worked, so I wonder how frequently this occurs. And talking about ICE, I jumped over to their website to look at the most current laws on the Dreamers. For those of you that don't know, DACA, or DACA, stands for Deferred Action for Childhood Arrivals. Apparently, on June of 2017, there was a memorandum sent out rescinding the ruling to defer action. Then, a few months later, in December, rescinded their rescension. Yeah, I just made that word up. With a few exceptions. It read, due to a federal court order, USCIS has resumed accepting requests to renew a grant of deferred action under DACA. USCIS is not accepting requests from individuals who have never before been granted deferred action under DACA. This is, by the way, just for legal parents without illegal children. The USCIS, or the U.S. Citizenship and Immigration Services, works directly with families, but it sounds like ICE is more of a government, scary borders, and find you and kick the terrorists out kind of capacity. Still, having been trained in the field as an international student advisor, who is responsible for aiding international college students in navigating that complex world of visas and figuring out how not to get held up at entry with who else? ICE agents. I went to a few conferences with NAFSA, the National Association of Foreign Student Advisors, which, by the way, can't we make that our acronym? Just Foreign Student Teachers, FST. I teach FST. I like the sound of that. I'll keep working on it. Anyway, at these conferences, they literally have an ICE agent call in and answer any questions they might have to clarify their legal obligations. Why can't we do that at our ESL conferences? Someone please correct me if you have ever had that happen. A general theme at these conferences was, it's a gray area, it's gray, it's all gray. We're just doing our best here, and it depends on which ICE agent the student runs into at the airport. Yikes. So I started asking Ed those questions that I'd always wondered about. What do I need to report to the state so I don't get in trouble in my job? And his response was pretty straightforward.
That's none of your business. That's not our business.
Ed gets pretty up in arms when it comes to defending our nation's children, even when it comes to those who do not belong to our nation.
The U.S. Supreme Court has held in 1984, Plyler versus Doe, that even children illegal, which is a horrible word, even children who are not here legally have a right to education.
One of the questions I asked Ed was that as a teacher, we're required to report a number of things we notice about our students that might hint toward a harmful home life. So, do I owe it to the state to report anything I see inside or out of school? His answer, of course, was no.
Well, first of all, it shouldn't be shared. But even if the school district is wrongly getting this information, hopefully they will keep it internally. The state has no right to know about Social Security of the student's parents.
So teachers are teachers 24/7, though. I mean, we tutor at homes and we go to school games to support our students and we chaperone after hours dances and fundraisers. So do we have any obligation to our students' legal safety outside of school? Well, he answered no. But I started asking some very specific questions. Say an illegal ESL student quits school to get a job to make extra money for the family. Am I required to report this student to the government or even to my school for that matter?
Well, based on my values, I do nothing. Okay, put it this way. I talk to the student, I talk to the parents, but I sure don't tell anybody else. And I don't believe you have an obligation to. But I'm telling you that we have a right to be both unobserved and unobserving. I'm not sure that's a good value. You probably don't have that right if it's a student when it's during school hours, but you clearly have that right otherwise.
I know this seems off topic, but I always wonder about shows like Moonshiners, where the people are clearly doing something illegal, it's on TV, and they never get arrested. In this case, I have students who are reporting to my school to receive an education and willingly putting on paper that they have no social security number and are sharing scary stories of how they got here illegally. Ed explained the roles of the system this way.
The constitutions of the states are like the Constitution of the United States. They say people are entitled. They don't say citizens. They don't say legal immigrants. I mean, so long as the stuff is kept internally, there's no repercussion. But the actual repercussion would be if this information is shared, whether it's with ICE, whether it's the Department of Education.
So in conclusion, no, we are not required to report our illegal students to the government. Our education runs on a different sort of playing field, it seems, when it comes to reporting. But even more baffling to me, which Ed never seemed to acknowledge, is that he still works hard to hold the schools to their legal promises of educational standards, promises they made to the government. Thank goodness for our profession. If anything is to be held in strict compliance, it is the standard of education nationwide. Again, my guest is civil law attorney and professor of law at Santa Clara University, Ed Steinman. Thank you for joining us, Ed.
You're most welcome. I wish you all the best.
If you have an opinion on this topic or any of our future topics, please tune in to the All Things ESL Podcast Facebook group, Instagram, and LinkedIn, where I post questions for upcoming episodes for you to weigh in. Also, join me on my website at allthingsesl.org. Thanks for listening. I'm Hannah Benson.